Undoubtedly, the 2002 Act is a special self-contained law, and Section 17 is a provision specifically dealing with the matters concerning searches and seizures in the connection with the offense of money laundering to be inquired into and the proceeds of crime dealt with under 2002 Act. We have already noted in the earlier part of this judgment that before resorting to action of provisional attachment, registration of scheduled offense or complaint filed in that regard is not a precondition. This is very important. The authorized officer can still invoke powers of issuing order of provisional attachment and contemporaneously send information to the jurisdictional police about the commission of a scheduled offense and the generation of property as a result of criminal activity relating to a scheduled offense, which is being made subject matter of provisional attachment. Even in the matter of searches and seizures under 2002 Act, that power can be exercised only by the director or any other officer not below the rank of deputy director authorized by him. Then Lords may kindly see paragraph number 313 on the same page. Consideredly, the Act 2002 Act provides for an inquiry to be conducted by the authorities and with power to collect evidence for being submitted to the adjudicating authority for consideration of confirmation of provisional attachment order passed by the authorities in respect of properties being proceeds of crime involved in the offense of money laundering. In that sense, the provisions of 2002 Act are not only to investigate into the offense of money laundering, but more importantly to prevent money laundering and to provide for confiscation of property related to money laundering and matters connected therewith and incidental thereto. The proceeds of searches and seizures under 2002 Act are therefore not only for the purpose of inquiring into the offense of money laundering, but also for the purpose of getting into the offense of money laundering. More importantly, to prevent money laundering and to provide investigation into a scheduled offense. And my lords may kindly take the material papers filed by the petitioners at page 143. Along with the affidavit, Millet. Page number 143. Well, it's in the main return filed by the petitioners. Well, in the impugned order, there are certain, kindly submit page number 143, paragraph number 8, bottom paragraph, that since Sri Pradeep Kumar was arrested for the contravention of Customs Act and is liable for punishment under the 135 Customs Act, and under section 135, section 35 is scheduled offense under clause 1 of subsection Y of 2, section 2 of PLMLA, the applicant department recorded an enforcement case bearing number so and so. After a report was forwarded by the DRA to an officer not below the rank of an additional secretary of the Government of India. At this point, it is pertinent to submit, since it is trite proposition of law that the customs officials are not police officers. They are not bound to follow Chapter 12 of the CRPC 1973, and as such, neither the registration of an FIR as contemplated under Section 154 of CRPC, nor filing a complaint is mandatory under Customs Act 1962. The standard procedure being followed by the applicant is that once a report is forwarded by the investigation officer to an officer not below the rank of Additional Secretary to Government of India, it commences its investigation by recording ECIR. In this case, only after a report was forwarded to the Principal Director General, DRI, having an equivalent rank of Special Secretary to the Government of India, the applicant commenced its investigation. Further, the scope and object of Prevention of Money Laundering Act 2002 is to prevent money laundering, which in plain terms means preventing legitimizing of money earned through illegal and criminal activities by investments in mobile and mobile properties and businesses concerns. And in the additional middle papers, just now I passed on, paragraph number 2 may be perused for a moment. This is the Director of Revenue Intelligence addressing the letter to the Joint Director Enforcement, Hyderabad, Miller. Page number 2, Your Lordships. This is the letter addressed by the DRI, Miller. Based on a specific intelligence that so and so, on 3-5 searches were conducted. And paragraph number 3, on page 3, further upon specific intelligence that the gold generated out of this modus is being fraudulently diverted and sold in the local market. Parallel operations were carried out, resulting in further seizure of 12 kg imported gold diverted from the SCZ. Subsequently, a search operation was carried out. Persons have been arrested, investigation in progress. This is for payment. Now, we have also placed on record the RAMC meeting in which the specific instructions were given to take up the case at serial number 59. It's 59. Page number 28, Lords Pakalis. Page number 28, serial number 59, Millet. This is Sri Krishna Exim LLP. On the basis of risk assessment, it was decided to record ECIR in this case. But therefore, my respectful submission is, Millet, it is not open for the petitioners to say that there is no scheduled offense at all. But having indulged into the smuggling the goods, and it is specifically found by the DRA officials, and they were also they taken into custody, they were arrested, produced before the court. Later on, they were discharged on bail. All these records unequivocally prove that they were indulged into smuggling of the gold, and 135 is being a special the scheduled offence under the PML Act. Once that is information is received by the PMLA authorities, it is independent of the Customs Act, the provisions provided under the Customs Act, the investigation which is altogether different. The PML authorities entitled to proceed independently to find out the tracing out of proceeds of crime. That is the purpose on which the basis, and the adjudicating authority has confirmed the retention order issued by the first respondent. And the appeal provision under section 26 and thereafter under section 42 before this honorable court is very much available to the petitioners. But at this moment, it is not open for the petitioners to say that since there is no scheduled offence at all, the ECIR cannot be registered against the petitioners. It is not open for them, is my respectful submission. Therefore, my respectful submission is, since alternative remedy is very much available to the petitioners, this writ petition has to be dismissed on that ground itself. That. Let's record discloses that they have forwarded the complaint as provided under the provisions, because immediately after freezing of order is passed, within 30 days they have to forward a complaint, and in the complaint itself they have specifically stated that freezing order has been already passed, and they have also prayed for retention of the properties under section 8. That is very much available. Kindly see page number 356, the original application. This was addressed very much within the time on 2710. That's not it. And the OS starts from 358. At page number 388, let me kindly look it into prayer portion. (388 minutes). In the facts and circumstances stated above, it is prayed that the retention of the record of property seized under subsection 1 of 17 may be granted under section 3 of 8 of PMLA. Continuation of freezing order in respect of bank accounts also is mentioned. (20) subsection 1, Lords may kindly see, there is no such May I read the subsection 1 of section 20? It does not indicate, that order to be passed. But 22, unnecessarily refers to passing of order. Lords may kindly, where any property has been seized under section 17 or 18 or frozen under section 1E of section 17, the officer authorized by the director in this behalf has, on the basis of a material in possession, reason to believe. But a reason to believe is very much available. We also reproduced. The reason for such belief to be recorded by in writing, that such property is required to be retained for the purpose of adjudication under section 8. Such property may, if seized, be retained, or if frozen, may continue to remain in frozen for a period not exceeding 180 days from the day on which such property was seized or frozen, as the case may be. The freezing order is very much available. The officer authorized by the director shall immediately after he has passed an order for retention or continuation of freezing of property for the purpose of adjudication under section 8, forward a copy of the order along with the material in its possession referred to in subsection 1 to the adjudicating authority in a sealed envelope in manner as may be prescribed, that such adjudicating authority shall keep this. So, already freezing order is passed and we have already forwarded the complaint to the adjudicating authority. Yes. Yes. That is my respectful submission. And even otherwise, if really the intention of the section 22 is to see that the retention order separately has to be passed, then under section 8.3 there is no specific reference to section 20. It's only the section 17, 17.1 and 1A. So if a separate order is passed, then that has to be confirmed by the adjudicating authority. But in case the freezing and retention of properties have to be confirmed under section 8.3. So there is no reference of section 20 under the adjudicating authority has to confirm only the freezing order. Therefore, my respectful submission is, even otherwise, maybe it's only for a interregnum period to prevent further misdeeds by the parties. Once the adjudicating authority confirms, the question of section 22 relying upon section 22 does not arise at all. because adjudicating authority has already adjudicated upon and passed orders for continuation of freezing and also retention of property. Therefore, at this moment, it is not open for the even to raise this ground at all.
Yes. Yes. I come to that. I'm aware, Milord. I brought you lordship notice also that he was arrested. And the provision is 107. Provision is the power of arrest is 107. Milord, now Milord, lordship kindly this. Lordship kindly consider two aspects, Milord. This special statute, that is the Customs Act, Milord, the scheme of the act is completely different from other statutes. The scheme is, Milord, one is at the threshold, they issue notice under 124, calling upon you, Milord, to give explanation. Then, Milord, pending prosecution of any person, there is a procedure for settlement. Even under 137, there is a procedure for compounding offences. Now, Milord, the core question that your lordships already posed earlier, whether, Milord, arresting a person under 135 would amount to, Milord, he being an accused in the schedule offence. That's the issue, Milord. So, lordship kindly consider. Under the PMLA, 135 is the schedule offence. It did not be, Milord, schedule offence means, Milord, a person should be accused of an offence under 135 as per the statutory provisions under the Act. My submission is, Milord, that 135 read with 137 contemplates, Milord, that there should be a sanction order passed by the competent authority before you lodge a complaint. Then, Milord, you have to lodge a private complaint. It shall be taken on file. Someone has to be issued. This is the procedure for the complaint procedure. Now, Milord, what they are alleging is, Milord, that he was arrested under 135. That is sufficient for us to initiate proceedings under the Prevention of Money Laundering Act. That's what is the contention, Milord. I bring to lordship notice, Milord. For a minute, your lordship kindly take 253, para 253, Milord. Yes, what my friend has, what my friend delayed is, Milord, suppose ED comes to the knowledge, Milord, that there is some property which is attached under 5. They can give intimation to the investigating agency. In this case, it has not happened. Investigating agency has given intimation to the Milord Enforcement Directorate. So those paragraphs 311, Milord, they are not applicable to the facts of the case. But Milord, one paragraph in Vijay Madan Lal, which directly deals, Milord, with this issue, lordship kindly take para 253 for a minute. 253 minutes, internal page 70. Yes, Milord. Here's we put, it is only such property which is derived or obtained directly or indirectly as a result of criminal activity relating to schedule offence can be regarded as proceeds of crime. The authorities under Act 202 cannot resort to action against any person for money laundering on an assumption that the property recovered from them must be proceeds of crime and that a schedule offence has been committed unless the same is registered with the jurisdictional police or pending inquiry by a complaint before the competent forum. But this is the finding given by the Milord, the latest judgment of Milord, the division bench. The lordships were aware, Milord, of the constitutional judgment of 1969. Here, Milord, Supreme Court has laid a ratio that unless a summon is issued, you can't treat a person as an accused. Milord, now, Milord, it's not like IPC, CRPC. These are the statutes, Milord, which are special provisions. Customs Act, they said the custom officer, Milord, is not is a police officer. Those statement made by the person is admissible and not violated for Article 23 of the Constitution. Milord, now Supreme Court has categorically stated, Milord, that he makes a statement as an accused at the time of his arrest. That doesn't mean he can be categorized as an accused under 135. That is the ratio laid down by the Apex Court. Taking that clue, Milord, to lordship kindly consider, taking that clue, the division bench has categorically held that there should be a criminal prosecution or a complaint as contemplated. That's the ratio, Milord. My learned friend may answer this. We are relying on Vijay Madan Lal. Milord, this is, Milord, as on today, Milord. This is the judgment which is ruling the field on all the aspects. Para 253 categorically state that there should be a complaint. You can't assume jurisdiction on the assumption that there is a schedule offense. You lost my kindly simulate that is evident from the circular, the letters addressed by the competent authority to ED, wherein there is no reference to 135. My lost my kindly take for a minute, the documents filed by Malayan Fed, page 4 minutes. Page 4. I'll ask the kindly take the document just of supplied, page 4. Well, ask me kindly note the date. Date is important. Page 4 minutes. Yes, but today supplied by the National Standing Council. Minutes. Date you lost me kindly see minute. This date is 3/8/2020. The arrest was made on 5/5/2019. That you lost me kindly note 2 dates minutes. This proceeding was communicated 5/5/2019. 19 minutes. 5/5/2019. After a lapse of 1 year, 4 months, they are communicating that a particular transaction had taken place by the petitioner. My lord may kindly say, I don't want to waste the time. Let my land friend may inform. Even there is no reference to 135. This is the only document that was communicated to Enforcement Directorate. Who did give Miller? Yes, I read clearly. Certainly, minutes. Information sharing matter. Seizure of 195 gold bars, foreign origin, weighing so and so, valued at so and so, from business premises of so and so. The Bureau has received a show cause notice, FN number so and so, from DRI Hyderabad Zonal Unit issued to Krishna Jewelry. So, then minutes. As per SCN, Krishna Jewelry Private Limited, also known as SKPL, is Krishna House so and so, Hyderabad, is involved in jewelry business and is engaged in designing, manufacturing, retailing, and exposing of diamonds, precious, semi-precious gold jewelry. Sri Krishna actually is known as SKELLP, is a unit of Hyderabad Gems Limited having office of Sri Krishna House so and so, Sri Krishna House Namjara Heights, has been granted approval for setting up a unit in SEJ. SKLP into business of manufacturing and export of gold jewelry studded with diamonds, precious stones. Sri Pradeep Kumar is the managing director, both SKLP companies. Then intelligence was developed by officers of DRA that SKLP is involved in diversion of duty-free gold bullion from its SEJ unit. Surveillance was mounted near Sri Krishna Jewelry Mart Gold Masjid, so and so, by the officer of DRL along with the 2 independent witnesses of so and so, who would be carrying 10 kgs of foreign mark gold bars to be delivered to Sri Krishna Jewelries. Thereafter, the officers instituted in Fonda car near the Krishna Jewelries, so and so, recovered 10 kgs of foreign mark gold bars. On the basis of the submission made by Venkatesh, such was conducted to the premises of so and so by the officers of DRL. 190 gold bars weighing 19,500 grams were recovered, which no relevant documents could be presented. Then minutes. Further, it is to inform that the basis of submission of C.V. Venkatesh, a total of 10 searches were conducted. The 9 searches and recoveries made was recorded in by so and so dated 26/6/2020. As per SCN, the following actions were proposed. Confiscation of 195 gold bars of 100 grams each, weighing 19,500 grams, valued at 6.3 crores, under 111D and O of the Customs Act. B. Penalty under section 112A, B and 170 of the Customs Act. The above information is being shared, necessary action has been fit. The action shall be taken. It's all Miller. Let put this communication, give them jurisdiction, Miller, to initiate prosecution under PMLA. My lords may kindly consider. This communication is the only material available with them. Miller, would it inform Miller that there is an offense under 135? No, prima facie, Miller. What you lords Miller Puri, I'll go further, Miller, later. Assuming prima facie there is a 135 minute, there should be communication. Without a schedule offense minute, they don't have jurisdiction to register a case to proceed further. It is the schedule offense minute which gives them jurisdiction to entertain a complaint. Entertain minute ECIR. Minutes. Now minutes, in view of this minute, you may kindly consider. For a minute, my lords may kindly take minutes before I go to the constitutional bench judgment. The provisions of the PMLA. Again, because this provision, millet, 3 million, whatever number of times period, for myself, I'm saying, number of times period, we get new dimensions from that. That's how it is framed. In fact, millet, when we, yes. But in other way, I may say, millet, the preventive detention is constituted to be a draconian law, millet, by many of learned judges in this country. Now a stage has come, millet, where this statute may have to be treated as a draconian law. The way in which, millet, the prosecutions are being launched without, millet, jurisdiction, on mere assumptions, millet, they are prosecuting. Millet, my lords may kindly see, millet, for a minute, what is the jurisdiction they get, millet, to register a case? How they get a jurisdiction, millet, under the statute? 3 minutes. Whoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, so and so. So, millet, the core question is whether he is in possession of the proceeds of crime for the purpose of this act, millet. Then 2U, last may come to 2U, millets. Proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of the criminal activity related to a scheduled offence. So, I brought to lordship notice already, without a scheduled offence, there cannot be any prosecution. Then, I'll come back to the complaint, 65 minutes, section 65 of the Act, for a minute. Yes, same Act. The provisions of the Code of CRPC shall apply in so far as they are not inconsistent with the provisions of this Act to arrest, search, seizure, attachment, confiscation, investigation, prosecution, and all other proceedings under this Act. So, investigation, inquiry, CRPC is applicable. They don't have a special provision without for filing a complaint and for taking cognizance. You have to go back to 200 CRPC. That you lost me kindly note. 200 CRPC. Under which they are authorized to file a complaint. There's 200 minutes. When a magistrate taking cognizance on offence and complaint shall examine on both the complaint and the witnesses present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complaint of the witness along with the magistrate, provided that the complaint is made in writing. He will not examine the complaint and witnesses if he is a public servant. So, 200 is one procedure for complaint procedure. 154 minute is the ultimate another procedure for the police report. Both minute culminate into 190 minute. You lost me take for a minute. 190. This is the only provision of the CRPC wherein the cognizance can be taken by the learned magistrates. Subject to provisions of this chapter, any magistrate of the first class or any magistrate of the second class, especially employed on the paper under section 2, may take cognizance of any offence upon receiving a complaint of facts which constitute such offence. This is under 200, first clause. Then upon a police report of such fact. That is under 154, culminating to 173. Then upon information received from any person other than police. So my submission is that till this stage of 190, you cannot term a person as an accused person under 135 Act in view of the special provisions contained in that statute. It differ from statute to statute. Even PMLA, there is no power to register FIR. They have invented some ECIR and they are doing that. But ultimately, they have to file a complaint. Before filing complaint, their power is given to arrest the person. So, in view of this, you lost me kindly see the judgment of the apex court. Don't be changed. Millet, Ramesh Chandra Mehta. Millet, we are relying on two judgments. Millet, one is by the Supreme Court, another by the learned single judge of the Gujarat High Court. Millet, where his lordship has explained. Millet, 1969. I'm sorry, Millet. Yes. Minutes. Yes, please. Yes. 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 Lordships are right. Yes, Millet. There are Millet, two facets, Millet, so far as the attachment is concerned. Without a schedule offence and without being a person and accused in a schedule offence, Millet, the authority is competent to attach the property. They have got the power. I am not Millet disputing that. But Millet, once you attach a property where there is no schedule offence, or Millet, where the person accused is not an offender in the schedule offence, 66(2) provides that you have to intimate to the investigating agency immediately to take up further action under the investigation. That's a completely different situation, Millet. May I suggest again, Millet? May I again submit, Millet? If Millet, they found Millet that some property 17, no, not only 17, Millet. If there is no schedule offence, what your lordship said right, Millet, there is no need not be a complaint, there need not be a final report. Even without a schedule offence, they can resort to 5. But Millet, 66(2) mandates you should inform the investigating agency immediately, forthwith, to see that the schedule offence is registered. Thereby, your jurisdiction is not vitiated. That is the scheme of the Act, Millet. But so far as the present case is concerned, according to us, Millet, till the complaint is filed, he cannot be deemed to be an accused under 135. This is a special provision, a special statute, where 5 judges of the apex court have answered that, Millet, that you lost my consideration. Once, Millet, after 5 judges judgment, any further, Millet, clarification is there, I definitely will come back. Because their lordships of Millet in categoric terms have laid down, Millet, that after the complaint is filed only, you can be treated him as an accused. Millet, schedule offence means, Millet, I should be an accused in schedule offence. Otherwise, merely by referring to schedule offence, you can't resort to Millet, taking all these Millet stringent action. Millet, you lost me kindly take Millet 69. That's AIR 1970 Supreme Court 940. I have given the judgment, Millet. Ramesh Chandra Mehta, the leading judgment on the Customs Act, wherein the statements were made admissible, Millet. On the Customs Act, the first. Pardon me. Millet, I'm really grateful to your lordships. Millet, your lordships suggestion made me, Millet, to look into this and come back. Millet, there the question was, Millet, that whether the statement recorded by the customs officer is admissible and whether Article 23 is applicable to such situation. Their lordships are negative. Only one paragraph I read with regard to that. Para 18 minutes. Para 18. We therefore agree with the High Court that the statements made by Mehta and other persons accused before the Additional District Magistrate 24 Parganas were not inadmissible in evidence because the protection granted under 23 of the Constitution. That's the finding. Then, so far as this issue is concerned, my lords may kindly take para 23 minutes, where the lordships of completely refer to the scheme of the Act of 1962. The scheme of Customs Act 1962 relating to searches, seizures and arrest and the confiscation of goods and conveyances and imposition of penalty may be briefly examined. Under 101 of the Customs Officer has power to search any person to whom these sections apply if the officer has reason to believe that such person has secreted about his pension, person, any who is liable for confiscation or any document related to it. Section 114 confers upon Customs Officer power to arrest if he has reason to believe that any person in India or within India Customs quarter has been guilty of punishment of 130. Every person so arrested must be informed of the grounds of such arrest. Section 105 authorizes any assistant collector customs to search any premises if he has reason to believe that goods liable for confiscation or any other damages or things which in his opinion will be useful for or relevant for any proceedings under the Act are secreted or in any place. He may authorize any officer's custom to search or may himself search for such goods documents. Under section 104(3), where an officer of customs has arrested any person under subsection 1, he shall, for the purpose of releasing such person on bail or otherwise, have the same powers and be subject to same provisions as the officer in charge of the police station has been subject to under code of the CRPC 1898. By section 107, any officer of the customs empowered in their behalf by general or special order of the collector or customs may, during the course of any inquiry in connection with the smuggling of any goods, this is relevant for our purpose. Requiring any person to produce or deliver any document or other relevant to the inquiry. B. Examine any person acquainted with the facts and circumstances of the case under 108 confers upon gazetted officer of customs the power to summon any person whose attendance is considered necessary to give evidence as to the production of document or any other thing in inquiry which such officer is making in connection with the smuggling of goods. The person so summoned is bound to attend and to state the truth upon the subject respective of examination of legal statements and produce such documents and other things as may be required, and every such inquiry shall be deemed to be a judicial proceeding within the meaning of 193 and 220 of IPC. Section 110 authorizes the officer to seize such goods as he chooses to believe to are liable to be confiscation to 111 to 127, deal with confiscation of goods and conveyance and so on. And then you will see, and after confiscation, an appeal lies to the appropriate authority at the instance of the person aggrieved by any order of such order passed by the Act within the time under 128. Under 130, the Central Board Revenue may exercise usual powers in respect to the orders passed by the subordinate customs authorities in 131 and authorize central government on the application by any person aggrieved by such orders specified therein to exercise such powers to annul or modify such orders. 132 to 139 deal with the offences. 10 minutes. So, to last me kindly note here that the settlement under 127A minutes can go up to the tribunal which is manned by judicial member. So, my submission is after 124 notice, there is interregnum of settlement. After settlement, if nothing happens, 137(1) sanction should be granted. And then the private complaint has to be filed on 137(2). Till that time, what is the status? You lost me kindly consider. Para 26, you lost me kindly take direct evidence. It is strenuously urged that under 104 of the custom, there are 26 minutes. It is strenuously urged that under 104 of the Customs Act, the customs officer may arrest a person only if he has reason to believe that any person in India within the Indian customs waters has been guilty of an offence punishable under 135 and not otherwise, and he is bound to inform such person of the grounds of arrest. Arrest of the person who is guilty of offence punishable under 135 and information to be given to him. It was contended to be a formal accusation of an offence, and in any case, the person who has been arrested and who has been informed of the nature of the infraction committed by him stands in the character of an accused person. We are unable to agree with the contention. Section 104(1) only prescribes the condition in which the power of arrest may be exercised. The officer must have reason to believe that a person has been guilty of an offence under 135, otherwise he cannot be arrested by such person. But by informing such person of the grounds of arrest, the customs officer does not formally accuse him with the commission of the offence. arrest and detention are only for the purpose of holding an effectively an inquiry under 107 and 108 of the Act with a view of judging confiscation of dutiable or prohibited goods and imposing penalties. At that stage, there is no question of the offender against the Customs Act being charged before the magistrate. Ordinarily, after adjudging penalty or confiscation of goods without doing so, if the Customs Superior forms an opinion that the offender should be prosecuted, he may prefer a complaint in the manner provided under Section 137 with the sanction of the collector of the customs, and until complaint is filed, the person against whom an inquiry is commenced under the Customs Act does not stand in the character of a person accused of offence under 135. This is 5 judges judgment. Till date, the ratio is not disturbed. You cannot call him as an accused unless there is a sanction and then a consequential complaint filed under 137(2). Then 37, one more paragraph. Section 167 of the Sea Customs Act, which was later came in Customs Act, contained a large number of clauses which describe different kinds of infractions, different penalties and punishments liable to be imposed in respect of those infractions. Under the Customs Act 1962, the customs officer is authorized to confiscate goods improperly imported into India and to impose penalties in cases contemplated by Section 112, 113. But on that account, the basic scheme of the Sea Customs Act is not altered. The customs officer, even under Act 62, continues to remain a revenue officer primarily concerned with the detection of smuggling and enforcement of levy of proper duties and prevention of entry into India of dutiable goods without payment of duty and of goods which may enter is prohibited. He does not on that account become either a police officer nor that the information conveyed by him when the person guilty of an infraction of law is arrested amount of making an accusation of the offence against the person so guilty of infraction. Again, I read the sentence. He does not on the count become either a police officer nor does the information conveyed by him when the person guilty of the infraction of law is arrested amount to making of an accusation of offence against the person so guilty of infraction. Even under the Act 1962, formal accusation can only be deemed to be made when a complaint is made before a magistrate competent to try the persons guilty of the infraction under 132, 133, 134, 135. Any statement made under 107, 108 Act by a person against whom an inquiry is made a customs officer is not statement made by a person. But this is the categoric terms that the apex court shall. You cannot accuse a person unless you contemplate to file a prosecution as contemplated under 137. Merely because there is a schedule offence, now you must kindly consider. They make a schedule offence. 3 persons are there accused, and then you want to prosecute 150% without making them as accused. That's what I'm arguing in other matters. The only exception is that when you want to make a person as accused, who is not accused of schedule offence, you have to inform under 66(2). That is the only way available. Now, this is the interesting case where fundamentally 135 cannot be treated as a schedule offence until the complaint is filed. Vijay Madan Lal, my lords may kindly see, this has been taken into consideration. Here are 253 the options of categorically again and again have held that unless there is a complaint, you don't have jurisdiction even to enter into this arena of PMLE. That is the ratio laid down. Lordship may kindly see that these are the acts where lot of responsibilities held on the officers are concerned. The officers are expected to act very fairly as per the statutory provisions of the Act. If they simply violate the provisions of the Act, arrest a person, take him into custody, they want to persecute a person for not committing any offence. 135 kindly consider. Till date, there is no allegation that he has committed offence under 135. Under the statute, they may differ. Suppose IPC you may see once FIR is registered, that's a schedule offence. 420 FIR is there. They get jurisdiction to prosecute the person. But this act, two purposes are there. The first purpose is to record the statement of an arrest. Then, penalty, confiscation, settlement. At any point of time, 135 can be initiated. We are not disputing that it should be only after the settlement. Anytime they can initiate. The officer may not initiate. That you lost my kindly consider. He may not initiate. He may think that's a case where no violation is made, or he may think that it's a case for penalty, or he may think it's a case for settlement. Then there is no question of 135. Milord, as long as milord, the 5 judges judgment is holding the field and milord 253 is not disturbed until a complaint is filed under 137, we have no jurisdiction even to milord register at ECIR. Not milord leaving that 5 or 17 milord or 8. Milord, interestingly, milord, your lordship has seen reason to believe is used in every provision. But unfortunately, that's not defined milord. But reason to believe is defined only in IPC milords. Lordship sir must have seen where reason to believe is defined, where milord, it should be milord to the subject to satisfaction. The officer will be completely satisfied before invoking 17 that he has committed an offense of money laundering. Yes, milord. Yes. Information. Yes, milord. With this paper, milord, scrap of paper, you lost me kindly consider. With this scrap of paper, can they come to the conclusion I committed 135? Or milords, or you lost me kindly consider, with this arbitrary action, can they justify their action that milord, the person has committed money laundering? Question is milord, 17 contemplates the violation of the committing of an offense of money laundering. 5 is milord only possession of milord proceeds of crime. Once milord, they come to the conclusion that higher footing. That's what I'm saying. This is because that's a freezing and seizing. Let's seizure and freeze. You watch me kindly say attachment millet is one thing different. Seizure and freeze, what happens? Millet, I got account millet operating my bank account. Well, attachment is with regard to the property millets. Freezing millet is the bank account. What happens? Millet, my monetary transactions are completely stalled. Thereby, a businessman cannot prosecute his business. That's where freezing happens. Seizure millet is the documents. Suppose I got a sale deed bill. They seize the document. So I am deprived of my right to alienate the property or mortgage the property. Attachment millet general order where I cannot alienate the property. This is 17 is a much millet harsher. Under 17, the power invested on the authorities millet is much harsher. Where millet the rights are violated. That's why millet the statute everywhere says reason to believe the reasons to be recorded in writing that he committed the offense of money laundering. He has committed the offense of money laundering provided there is a criminal activity related to schedule offense. When there is no schedule offense, the question of committing criminal activity doesn't arise. But this is an interpretation which is required to be made by your lordship's because I'm not arguing on a lordship. Again, I read that's at 253. This is the law laid down with the apex court. Though going for review for all the now review is there before the apex court, but as things stand, we are bound by this. I just read this that will only one sentence. The authorities under 202 Act cannot resort to action against any person for money laundering on an assumption that the property recovered by them must be proceeds of crime and that schedule offense has been committed unless the same is registered with the jurisdiction police, that is 154 minutes, or pending inquiry by way of a complaint before the competent forum. So, this sentence, this paragraph, read with 1969 constitutional judgment, it's categorical that unless a sanction is given under 137(1) and complaint is filed under 137(2), you cannot treat the person as an accused of accusation of 135. So, there is no schedule of this. Other paragraphs also similar with regard to the 3 standalone. Sorry. Other paragraphs also similar. Vijay Madalla, I read to lordship's where it is categorical that you cannot invoke 3 without there being schedule offense. 69 judgment I have verified that is holding the field. There is no ratio is not changed so far. So far as Customs Act is concerned. In view of this there are no. Sorry. Yes. Yes. Milord, yes, please. No. For a minute, your lordship is 17 contemplates seizure freezing. One is freezer, sorry, one is seizure under 17(1), then 1A freezing of the account. These are the two. But retention and continuation is not contemplated at 17. That you will also kindly consider. Seizing and freezing is one aspect. Yes, you seize and freeze. Then you come to the conclusion that this has to be continued. For continuation is called retention. Retention and continuation under 20. There should be a separate order passed under 20 for retaining and continuation. They can't club it. Seizure and freezer cannot be clubbed with retention. Retention is a separate provision. You must be kindly similar. I read again 20 minutes. Retention of property. Where any property has been seized under 17 or 18 or, sorry, 20 minutes. Where any property has been seized under 17 or 18 or frozen under subsection 1A of 17. So this is one aspect. They have seized and frozen. The officer authorized by the director in this behalf has, on the basis of the material in portion, reason to believe, the reason for which belief is to be recorded by him in writing, that such property is required to be retained for the purpose of adjudication under 8. Why will they use again the word reason to believe? Already reason to believe has come in 17. Rashmi kindly say 17, there is already reason to believe. There is no need for the legislature to again import the word reason to believe under 20. If there is a one proceeding, there are two different proceedings. You have to apply your mind first at the time of why they have put it this minute. Today they seize and freeze the account. Then they go back to the office. After 2-3 days or one day they come to the conclusion that the seizure is by mistakenly it is made, or there is no need to continue the seizure or freezing. They can close it. Once you want to retain it, 20 contemplates that you should again apply your mind. That's my kindly say. There is no need for using 2 times the reason to believe. Every time reason to believe is used in different provisions to see that a separate proceeding in writing is to be prepared. 20 contemplates again you will kindly see. Reason to believe, the reason for such belief to be recorded in writing. So 21 contemplates again writing a reasoned order for retaining. Then 20 clause 2. The authorized officer by the director shall immediately, after he has passed the order of retention and continuation of freezing of the property for the purpose of adjudication, forward a copy. Well, these two are completely two different facets. They can't be clubbed. My land fund. One, not 17. It's one only minute, not 17. But only one aspect. You lost me kindly see from 3, 5, 8, 17, 18. This 20, everywhere they use reason to believe in record in writing. What is that? What is the meaning of that? You have to again apply your mind, record reasons in writing briefly, then only proceed further. It can't be the reasons record under 17 are suffice under 20. It can't be argued reasons record under 17 are suffice to 20. So these are two different facets which have to be separately have to be. That's why they escaped. They just vaguely they denied. They have not given clarification that they passed an order under 21. Now their case is they did not pass an order. The authorities they cannot go to such action. With great respect, we are assisting your lordships. When my friend is briefed by the officers, they should. This must be come up for consideration. 1 and 2 you can't say that 17 order is sufficient under 20. When you have not denied in the counter affidavit, you should gracefully admit yes, there is no order 20. Should be, you have to otherwise. No, with great respect, we also were there, we never felt afraid to state that there is a fact. Earlier, your lordship was 40, 50 days convince or confuse. Now, convince or concede. That is the situation now. You have to concede if you don't convince. Great respect, 20 is not complied with. Thereby, the proceeding entirely has to be is vitiated even from the stage of 20. Apart from the principal ground, you lost me kindly consider. That's a very interesting ground so far as the Customs Act is concerned. I'm not arguing in general. It's only relating to Customs Act. Then we have the constitutional bench. Where Millard, the lordship says, after following Millard, the 1969 judgment Millard, the main purpose of provisions of 9, 13, 18, 19 of the sentence. 26, 3 minutes. There are 26. Yes, ma'am. But yes, 3 minutes. You also kindly go to directly 3. A customs officer is not a member of the police force. He is not entrusted with the duty of maintaining law and order. He is entrusted with the power that specially relate to the collection of customs duty and prevention of smuggling. The power to arrest, the power to detain, the power to search or obtain such warrant, and the power to collect evidence are vested with the customs officers for enforcing compliance of the provisions of the Sea Customs Act. The customs officer does not exercise when the inquiry into the suspected infringement of the Sea Customs Act, powers of investigation which a police officer may in investigation of the Commissioner of Affairs. He is invested with the power to inquire into the infringement of the Act primarily for the purpose of adjudicating forfeiture and penalty. He has no power to investigate an offence triable by magistrate. He has no power, nor he has the power to submit a report under 173 of the CRPC. He can only make a complaint in writing before the competent magistrate. The expression any person includes a person who is suspected or believed to be concerned in the smuggling of goods, but a person arrested by a customs officer because he is found in possession of smuggling of goods or on suspicion that he is concerned with smuggling of goods is not when called upon by the customs officer to make a statement or to produce a document or thing and a person accused of offence under 23 of the Constitution. The steps taken by the customs officer are for the purpose of holding an inquiry under the Customs Act and for adjudging confiscation of goods dutiable or prohibited and imposing penalties. The customs officer does not at the stage accuse, this will also make a the customs officer does not at that stage accuse the person suspected of infringing the provisions of Customs Act with the commission of any offence. His primary duty is to prevent smuggling and to recover duties of custom when collecting evidence in respect of smuggling against a person suspecting an infringement of the provisions of the Customs Act. He is not accusing the person of any offence punishable at a trial before a magistrate. When the customs officer arrests a person and informs that person on the grounds of his arrest, which he is bound to do under 22(1) of the Constitution, for the purpose of holding an inquiry into the infringement of the provisions of the Customs Act, which he has reason to believe has taken place when there is no formal accusation of an offence. In case of any offence of infringement by the Customs Act, the punishable at the trial before the magistrate, there is an accusation when a complaint is lodged by an officer competent in the behalf before the magistrate. You lost me, kindly say that sentence, Millard. In case of 5 Millard, last sentence, in case of an offence by infringement of the Customs Act and punishable at the trial before a magistrate, there is an accusation when a complaint is lodged by the officer competent in the behalf before the magistrate. Arrest and detention are only for the purpose of holding effective an inquiry under 107, 108 of the Customs Act with a view to adjudging confiscation of dutiable or prohibited goods and imposing penalty. At that stage, there is no question of the office offender against the, at that stage, there is no question of the offender against the Customs Act being charged before the magistrate. Ordinarily, after adjudging penalty and confiscation of goods or without doing so, if the customs officer forms an opinion that the offender should be prosecuted, he may prefer a complaint in the offender should be prosecuted. He may prefer a complaint in the manner provided under 137 with the sanction of the collector of customs, and until the complaint is so filed, the person against whom an inquiry is commenced under the Customs Act does not stand the character of a person accused for an offence under 135. This is what the constitutional bench has held, that the learned judge has been simplified and has given elaborately. Until 135, 137 proceedings are initiated and complaint is filed, there is no accusation. Schedule offence means not the offence. There should be an offender in the offence. According to this judgment, he doesn't be characterized as an offender till the complaint is filed. That's my simple submission. So there is no offender in the present case because that stage has not come. It is only at the stage of 124. Hence, there is no schedule offence. He cannot be prosecuted, nor any action can be taken under that. It's my respectful submission. Highly obliged,
Well, only I wanted to clarify, Millard, only the section 20, subsection 2. Well, it is, if that is the real intention of the legislature, Lords may kindly see section 8 of the 8.3 for a moment. 8.3, my lord. Adjudication process, adjudicating authority. Because after the 8.3, Lords may kindly see, where the adjudicating authority decides under subsection 2 that any property is involved in money laundering, he shall, by an order in writing, confirm the attachment of the property made under section 5.1 or retention of property or seizure or frozen under section 17, 18 and record a finding to that effect, whereupon such attachment or retention or freezing of the seized property or shall continue investigation for a period of not exceeding 360 days, pending the proceedings relating to any offense. My respectful submission is, if really that is the intention, there must be some place under 8.3 also, or under section, entire provision, to confirm any order, retention order passed by the authority. There is no such specific provision referred to in 8.3, because 8.3 only the adjudicating authority has to adjudicate upon the reference of complaint, original application made by the director. That's all. That is all. And yes, yes, true. Attached. Yes.
Good attention. Yes. Minutes. 21 says no reasons to be recorded. That minute they cannot, unless minute there is duty, there is an obligation to record reasons, minute there is no need to write that.
May I seek your lordship's kind leave, my lords? May I submit, my lord, before I seek your lordship's kind indulgence to subject your lordship's view on the matter. My lords, in fact, the government pleader, when the matter was taken up, ought to have brought to your lordship's kind notice about the distinguishing feature of the case which was decided by the Andhra Pradesh High Court. My lord, that was a administrative order where under the deferment has happened. But whereas, my lord, in our state, there was an act brought in, preceded by an ordinance. That was the only difference, my lords. Otherwise, there is nothing in this matter. Even the argument before the Honorable Supreme Court was that you can't trace to an administrative. That your lordship may kindly permit to withdraw. But subject to your lordship's call. That is the only thing, my lords. Otherwise, there was nothing in this. My lords. Obliged, my lords.
Three items.
Wait this. Well, they were to produce the files. Yes, lordships.
The note file, my lord.
My lord, one more submission, my lord. I got the DO letters also. The reference is there, my lord, in the proceedings, that note file. These are only, yes. And this was addressed to PMO's office, but I do not have the original copy. Photostat copies. Yes.
Five-star.
I have given the circulated file also. Just now I circulated the. Yes.
But we'll also go through the note file. Yes, he has given us,
Just now I
he has given me a copy.
I have just got a copy.
Same
I just got, we'll go.
Lordship, I have it next Tuesday or so, man.
I am out of the country from tomorrow, I had indicated on the last occasion. So if your lordship will have it after 5th of July, then it after 5th of July. Meantime, I'll have a look at it. Well, that. Yeah.
No worries. My foreign trip was to my village.
I was in my village in the first half. Second half, I am going to my daughter.
The thing is, I don't have such phases. 5th July అంటే ఈ రోజు చూడు నేను మళ్ళీ 8th July నుంచి ఉండను.
Much obliged.
I'm very glad. Let's see.
Petitioners were the employees of this honorable court, combined High Court of Telangana and Andhra Pradesh. They were initially allotted not to the High Court of Telangana. But that your lordship, my lord. Now, my lord, after being allotted, they were again allotted to Andhra Pradesh. They want to come back to Telangana High Court. That's all is the belief sought for. The lordship may issue notice. Right? No, I opted for Telangana High Court, my lord. I was allotted to Telangana High Court. Later, my lord, it was changed. Brought by proceedings dated 18/1/2019. I was just an overleaf in the list of dates, my lord, just which I have given to you. 18/1/2019. My lord, I have been allotted to Andhra Pradesh. My lord, this is a second allotment on my representation. Correct. On my representation, I wrote, my lord, on my representation, I was allotted to Andhra Pradesh at a second stage. Now, my lord, after your lordship, my lord, this honorable court allotted us to Andhra Pradesh. Andhra Pradesh, my lord, High Court says that we will be at the bottom of the cadre. My lord, my humble submission is this. It's a, no, I exercise, the issues are this, if your lordships are kind enough, I put the issue like this. Allotment, it was said that option once exercised is final. I have exercised my option to Telangana. I was sent there, will your lordships kindly have a look at the memo, along with the memo, this proceed. I'm not no, I just make one. I understand. I understand. I'll just make my one submission and leave there. Can no. Will your lordships kindly just at the time, Lord, when your lordships, my lord, allocated me to Andhra Pradesh, or when all other persons were allocated to Andhra Pradesh, there was no condition that, my lord, they should take the bottom seniority. They were absorbed here, my lord. And no, they were absorbed here, my lord. Again, is there, my lord, absorption, my lord, the High Court employees here, my lord, is. Yes. Yes. One Mr. N. Narayan Rao and one Mr. Narayan Rao and T. Bhuvaneshwari. I'm only just trying. They, my lord, they made that request. They were here on deputation. They were here on deputation, not allocation. They were here on deputation. But this severance, my humble submission is this severance came severance of my relationship with High Court of Telangana came in, can I, Mulad, Mulad, can I just take your lordships to Mulad, your lordships guidelines, Mulad, your lordships, Mulad, Mulad, in the no, Lord, your lordships are very clear on that, Lord. Perhaps we will try to persuade your lordships, Lord, on certain things. It's not as if not your lordships. We will be under the impression saying that your lordships did not understand the case. Lord, we will never be under that impression. No, Lord, there may be some other, Lord, way of looking at it. I'm trying to put it on that fashion. If your lordships are some, Lord, it's a matter for examination. This honorable court, a division bench of this honorable, may I just, no, my humble submission is, I put it, I did not make myself clear. No, I'll put it this way. Your lordships have issued guidelines, Lord, for allocation of employees of the High Court to High Court of Andhra Pradesh and High Court of Telangana. Lord, the process of allocation gets completed. Lord, on the first occasion, on the first occasion, Lord, on 31/12/2018. Can I just, with your lordship's kind permission, Lord, I do not, Lord, can I just take your lordships to Lord, page 23, where your lordships have issued guidelines, Lord, can I just take that? Sorry, Lord, I may be troubling your lordships, Lord. These are, can I read, Lord, at page 20? I'm reading, Lord, the third line on the guidelines and the option forms are herewith circulated to the officers and staff of the High Court of Judicature at Hyderabad for the state of Telangana and state of Andhra Pradesh to express their options for consideration to be continued in the service of the High Court at Hyderabad, which would be the High Court for the state of Telangana, and for being duly considered for induction and absorption to the service of the High Court of State of Andhra Pradesh upon its constitution. Therefore, all the section officers, section heads are hereby directed to circulate the guidelines and option forms to all the staff working under their control to exercise their options in the prescribed form. All employees are working in the respective sections of the High Court shall submit their filled-in option forms in sealed cover to the section officer, section head on or before 15/11/2018. The section officer, section head in turn shall effect the duly filled-in option form from the employees in a sealed cover and submit the same in a separate sealed cover, superscribing as option form of the respective section to the Secretariat of the Honorable Chief Justice, High Court of Judicature at Hyderabad on or before 15/11. This has been completed. Murad, your lordships issued the guidelines at page 24. Your lordship. Then, my lord, kindly permit me to read one option. Can I read? For the purpose of these guidelines, option means exercising option by the officers and staff of the High Court of Judicature at Hyderabad for the state of Telangana and state of Andhra Pradesh for consideration to be continued in the service of the High Court of Hyderabad, which would be the High Court for the state of Telangana, and for being duly considered for induction and absorption to the service of the High Court for the state of Andhra Pradesh upon its constitution. Then, my lord, kindly go to, my lord, 6, my lord, guideline 6. All the employees, can I read? All the employees are required to exercise option in a prescribed pro forma, indicating their preference to serve in either of the High Court within the time prescribed. Then, my lord, 7 is, if no option is received within the prescribed time, such employees shall be allocated on the basis of particulars available in his or her service records at the discretion of the Honorable Chief Justice. Options of the employees shall be considered first for allocation in the order of their seniority. Then, my lord, kindly omit all other things. Kindly go to last one, 18, my lord. Notwithstanding the guidelines indicated above, Chief Justice would be at liberty to consider any principal factor which may become crucial in deciding the allocation of the employees to the High Court of the respective states. My lord, on the basis of these guidelines, your lordships, my lord, issued proceedings dated 31/12/2018 at my lord page 27. Can I just take it? Page 27. Yes, sir. Yes. Yes. My lord, can I just request your lordship? My main prayers are prayers A and B, my lord. My main prayers are prayers A, B, C. My lord, this, my lord, A, B, C, my lord, your lordships can only decide, my lord. This honorable court, my lord, can I just take your lordships to, my lord, no, this, no, my lord, I, I'll be happy, my lord. I'll be happy with prayers A, B, and C. My lord, prayers A, my lord, my lord, I am only putting this way. For prayers A, B, and C, this honorable court, my lord, a division bench of this honorable court has held saying that this honorable high court alone has got the jurisdiction. No, my lord, this is what I was trying to submit. My lord, my humble submission is, I was sent there on deputation, my lord. No, can I'll just take your lordship. No, my lord, can I show one more paper to your lordships and leave it there? My lord, page 27, your lordships have been looking into. Can I just take? No, my lord, this is allocating me to, my lord, state of High Court of Telangana, my lord. This paper is allocating me to High Court of Telangana, my lord. This is what I am trying to submit. No, I'll just one factor, my lord. Can I just only one factor leave it there? Only one factor. No, only this one factor I'll state. I leave the things there, my lord. I'll not argue anything. Kindly just kindly just have a look at this. Kindly permit me to take your lordships to this paper and leave it there. Only this paper, nothing more. Can I just take page 27? Just one paper, kindly. Paragraph 2. Can I read paragraph 2? The officers and employees shown in the appended annexure 2 are deputed to work in High Court of Andhra Pradesh at Amaravati or to the subordinate courts in state of Telangana as mentioned in the annexure. But persons who were included in annexure 2 were only sent on deputation, my lord. My humble submission is this. And your lordships kindly have a look at, my lord, page 54. Sorry, page 53, my lord. Page 53. Can I just read the heading? Following officer, though opted to the High Court for the state of Telangana, in view of the absence of number of vacancies in the cadre of section officers, they are deputed to work in the High Court of Andhra Pradesh. My lord, petitioner at serial number 35, your lords gets at the bottom, then kindly just have a look at page 54, serial number 50. Then, my lord, in the same next box, my lord, serial number 4, Nagajyoti. Then, my lord, page 55, serial number 17. These are, we were sent there on deputation, my lord. This is the submission that I am trying to, my lord, impress upon your lordships. Thereafter, my lord, your lordships, my lord, on my representation, no, representation I could not file, but I filed that proceeding. 1 second, I have stated, but I have filed that memo, your lordships, the memo issued by your lordships, my lord. On my representation sending me there, my lord, I filed this memo, my lord, along with USR number 44020 of 2000. Lord, representations were not retained, my lord. We asked you. Can I just take? No, I did not have the copy, my lord, otherwise I would have placed. 18/1/2019, your lords got, my lord. Picture in memo. Lord. Correct. Correct, my lord. Your lordships are absolutely correct, my lord. Your lordships have sent us there instead of on deputy. On my request. On my request, my lord. There is no hiding things, my lord. On my request, my lord. I did not have the copies, my lord. Therefore, I did. If I had those, my lord, these proceeding, can I just? My lord, after, my lord, your lordships passed this order on the administrative side, my lord, sending to High Court of Andhra Pradesh, my lord. There they issued a proceeding stated 1/3/2019 saying that we will be at the bottom of the cadre. We went on making representation saying that we came here on allocation. Then give us our whatever is due, counting the service which we have rendered from the beginning. That was rejected by the High Court of AP. Then we are here before your lords. I leave it there, my lord. I go by my word. I'll not press anything further. This is what I have. I am Surendra Rao. Here. Only for the purpose of enabling your lordships to, my lord, this is your lordships will get this line. My lord, order in, my lord, WP number 16188 of 2019, my lord. At page 54, it starts at 142 is the relevant portion. Sorry, page 113 it starts, my lord. 142 is the relevant portion. Paragraph 54. My lord, there persons, my lord, who were, yes. That was undischarged. Prior to, my lord, 3112. In that connection, my lord, right? I'm only right. I'm only trying to bring this decision to your lords. Paragraph 54 of this. Leave it there. I leave it there.
Lord, I informed the other side also. 24th of July, my lord.
Yes.
Yes, my lord. 24th of July. Obliged, my lord. I am sorry for troubling.
May I please, my lord, have been filed the public interest litigation, my lord, seeking the prayer, my lord, direct the financial institutions, my lord, to sanction the mudra loans, my lord, on par with the national average of 25%, my lord. My humble submission, my lord, the mudra loan, my lord, is introduced, my lord, for the purpose of, my lord, my lord, my lord, small scale industries and, my lord, some small business, my lord, that is true, Millard, but because Millard, the petitioner is running the Millard NGO organization, he is fighting for the Millard. Millard, I don't want to take any credit out of this case, Millard. My interest is Millard only to Millard to help the Millard poor and needy and who are Millard small and yes, Millard. And moreover, Millard, they are Millard small sector industries. Millard, nowadays the Telangana, Millard. Millet. Not bonded laborer, Millet. We are Millet applied the loans, Millet. Millet, not 1 crore, Millet. Millet, not 1 crore, Millet. It is only below the 50,000, above the 50,000 until 10 lakhs. And moreover, Millet, these loans have categorized Sishu, Kishore, and Tarun. And moreover, Millet, small Millet business people who are running on the carts. Millet, only Millet, I don't want to take any credit, Millet. At least take a sumo to at least Millet. My endeavor is. Millard, in this case, Millard especially, there is no any Millard publicity for the purpose of. Yes, Millard, there are. Yes, Millard, there are cases. Yes, Millard, I do agree, Millard, but yes, Millard, but there are Millard, there are. I do agree. Yes, yes, Millard. Millard, I placed before you the. No, there are cases, Millard. In this case, Millard, I don't have any personal interest in this case, and I don't want to. My only endeavor, Millet, to help the needy, Millet, those who are more or less Telangana, there are. Millet, in Parliament, Millet, there is. No, definitely. Yes, yes. A petitioner is regularly filing Millet public interest litigation. He succeeded also. He succeeded also. I leave it to your lordship.
Lord, in this petition, Lord, the three writ petitions, Lord, concerning 3 assessment years. Lord, the prayer is not to, Lord, the transfer, yes,
My lords, I'm
the
appearing.
advance tax,
My lords, I'm appearing for the petitioner on VC, and my lords, mic is on mute. I can't hear my lords. I can hear my learned friend, but I can't hear my lords.
Mandin, we can hear Madin Krishna. Not advance tax and TDS credits, lot of the transferor company, but they seek migration of that note to the transferee company writ petitioner and not consequential refunds. But I was asked to not get instructions with regard to the same. But I have received the instructions. May I just pass on? Lord?
Lord, my learned friend has given me a copy of the instructions today morning. I have a copy.
Yes, I have given a copy to them. Yes. Lord, this dated 8/6/23. The C company Virtusa Consulting Private Limited filed writ petition so and so relating to assessment years so and so respectively. Issue involved in these years was regarding non-passing of rectification orders and not granting refunds. Facts of the case are Polaris Consulting and Services Limited got merged with Virtusa Consulting Services Limited by order of NCLT in the case number so and so. Consequent to such merger, SC company VECSL requested to allow credits of taxes paid by PCSL, that is the transferee company, the merged entity of VCCSL. Due to some technical errors, the credits could not be migrated to the emerging entity VCCSL. Since the rectification orders could not be passed, VCSL filed the above three petitions. From the Honorable so and so, then last paragraph. In compliance with order, hearing of the Honorable High Court, the comments are as follows. Now kindly take note, each assessment year we have given separately, writ petition. Note does WP 6637/23 relates to note 2018-19. The SC company Virtusa Technologies Private Limited and Virtusa Software Services Private Limited merged with Virtusa Consulting Services Limited with effect from 1/4/17 by order so. As per request of the SSC, we have initiated the migration of advanced tax challans and TDS challan paid in Virtusa Technologies India Private Limited amounting to 13 crores 21 lakhs 14,624. Further, the same are successfully migrated to Virtusa Consultancy Services Limited as requested by the SSC. Presently, jurisdiction over the case of Virtusa Software Services Private Limited, Westwich Chennai, Circle 31 Chennai. This office has sent request for the migration of PAN from Circle 31 Chennai through email dated 23/5/23. Once the PAN is migrated to this office, advance tax and TDS challans paid in Virtusa Software Services Private Limited will be transferred to Virtusa Consulting Services Limited. However, note here, your lordship will note, further it is pertinent to mention that the SSC company VCSL filed a writ petition number WP 27286 of 2021 against the draft assessment order under section 144C of the Act passed by the NFAC dated 30/9/21. As per the request of the SSC, the Honorable Court granted an interim stay and instructed the AO not to pass final assessment order till the disposal of the writ petition. During pendency of the stay on the draft order, a final order cannot be passed. Hence, no credit of advance tax and TDS can be given unless the stay is vacated and final order is passed. So, insofar as this is concerned, not in view of the stay granted, he's not disabled from passing a final order. Otherwise, in principle, everything is migrated. Then, WP number 6636 of 2023, assessment year 1920. The company PCL merged with so and so, and on the request of applicant, proceedings for migration of advanced tax and TDS challan were initiated and sincere efforts were put to migrate advanced tax and TDS challan. TDS credit of PCSL got migrated to VCSL. This your lordship may know. The migration of advanced tax is pending. The credit of advanced tax could not be given to VCSL as the aforementioned challans are not appearing in the ITBA module while issuing the rectification order under 154 of the Act. In this regard, various tickets on ITBA help desk were raised to resolve the issue, and mails were sent to ITBA team regarding the technical difficulty. The ITBA in response to ticket number so-and-so communicated as follows. Blood ITBA's that is help desk was I forgot. I'm sorry. Right now I forgot. It is the I know, but just gone out of my mind. Yes, sometimes yes, that is so. But I'll just ITBA on to Nakal. Thereafter, various correspondence took place with ITBA and CIT CPC for speedier resolution of the issue. In reply to ticket number so-and-so suggested to pass nil order under 154 on old entity PAN with name of new entity in the order to convert consumed challan into unconsumed challan. Reply of the ITOS in yes. Now, the difficulty expresses here.
My lords, I'm very
Now, what they have said, I'll just.
My lords, I'm very sorry to
They
interrupt.
have suggested the following steps, Lord, 1, 2, 3, 4. That is, in 4, they say, Lord, rectification may result in demand for old entity if challans are consumed and any refund has been paid to old entity. So that issue is there. However, no provision under the Income Tax Act to pass any order on non-existing entity. The so-and-so may kindly bring this back to the notice of the Honorable Court, seek further directions, give deep fit. Also, in the event of demand being raised on PAN of old entity as suggested by team, necessary directions may kindly be obtained by the Honorable Court to protect interests of the revenue. This is income tax business application, ITBA. Now here, Lord, what they have suggested is, you pass an order under 154 on the old entity, but with the old PAN and the new name of the SSC, and then but pass a nil order. That will enable them to migrate it to the petitioner SSC. However, not doing so may result not. I mean, while for passing the assessment order, not rectification order, in reality, it may not result in a nil assessment, but may not result in a positive demand against them, because according to what our instructions, they have already been consumed by the old entity. So it has to be unconsumed and not migrated to the petitioner entity. If that is done, not if a demand is raised, not direction, that is one aspect. The second aspect is, since there is no entity in existence now, and the Act doesn't provide for such a situation, your lordship can always direct that an order be passed under 154 in respect of the old entity. This is only with regard to not advanced tax. TDS is already given credit to. Then WP 6638 2021. Challan from PCL to VCL CSL has been successfully migrated since there were no consumed challans. In previous attempts, the order could not be uploaded and showing error as manual order cannot be uploaded for this PAN assessment year as processing of original return under 140 is still pending in CPC. However, with constant effort, the order got uploaded manually on 7/6/23 and credit for advanced tax and TDS was also allowed, resulting in a refund of 51.66 crores. So insofar as this year is concerned, everything is done. But insofar as about 1819 is concerned, because of the tendency of the writ petition, where there is a stay with the insoluble force, no difficulty is there. And in respect of 1920 assessment year, TDS is already given credit to. Advanced tax, we have this difficulty because it has already been consumed by the old entity. So we'll have to unconsume that by passing a rectification order on that. And if it results not in positive income there, not in the department's interests have to be protected. That is the thing. And direction we should not to allow the assessing officer to. Yes. Yes. 1920. Yes.
My lords, I'm very sorry to interfere, but I still can't hear my lords.
But we have passed on these instructions. They can always get instructions from the client if they would so wish, not what we have stated.
I can't hear my lords. I'm extremely sorry for this, my lords. I can hear my learned friend, but I can't hear my lords.
But
Then what is to be done? Oh,
you can make your submission.
My lords, may I meet the arguments?
Yes, please.
yes,
Okay.
yes, yes, please. Yes.
Yes, my lord. Yes,
My lord, as far as the
my lord, as far as the
assessment
assessment
year
is concerned,
2021
that they are no because in that there are no reservations of the department. My lord, the order that they have passed recently on 7 June takes into consideration
all aspects which I have asked
all
for in my
aspects
prayer.
which I have asked for
My
in
lord,
my
my
prayer.
first humble
My lord, my first
submission
humble
before my lords,
this one can be disposed
this one can be
and they can be
disposed of,
directed
and they can be
to
directed
give effect to this order
to give effect to this order in a time-bound manner.
So my lord, this matter can be
My
closed
lord,
because
this
there is no
matter can be
dispute
closed because
for
there is
this
no dispute
assessment
for
year,
the AY
this assessment
2021,
year, which is AY
serial
2021.
number serial
Yes.
number.
This can be disposed of. Yes.
Yes, my lord.
Yes,
They may be
yes, ma'am.
directed to
My lord, they
comply
may be
with the order
directed to
and
comply
issue
with the
its
order
refund in a time-bound manner, 4 weeks, 6 weeks, whatever flows from my lords, along with applicable interest. That's my only request.
Just with some reasonable time may be given.
Item number 11.
Right.
Order sheet. For the respondents. By filing this petition under Article 226 of the Constitution of India, petitioner has prayed for the following reliefs. Page 4, A to A. Matter relates to migration of advanced tax
So brief.
What about the other two?
Yes, my lords. Now, my lords will please see serial number 9, which is for assessment year 1920, my lord.
Yes.
1920.
Yes, my lord. My lord, the point that they are raising that advance tax has been consumed, it has been consumed at their end. We haven't consumed it. We have even given an indemnification bond for this.
Hmm.
If my lords will see a manual order which was passed, which is my lords, an extra P10, page 339.
Three three nine.
339.
Yes. Yes.
Yes, my lord. My lords will see serial number 9. My lords, in the chart which is given, my lords.
Yes.
My lords, in serial number 9, they have already given us the TDS credit of the merged entity, which is Polaris. So they have accounted for the TDS credit of Polaris. However, in serial number 10, they have not accounted for the TDS credit of the advance tax credit of Polaris. So this order partially complies with our prayer because TDS of Polaris is accounted for. However, advance tax of Polaris is not accounted for. And my lord, when we have filed our revised return, all incomes of Polaris have been shown in the hands of the petitioner company now. So if the income is being assessed and has been offered to tax in the hands of the petitioner company, the corresponding advance tax and TDS also moves here. And we've given an indemnification bond also, which is on record, my lords. The consumption of the advance tax is at their end, not at our end. Well, the technical problem that which I think they are facing is that they have already shown a certain amount of advance tax against the PAN of Polaris. They have to manually or by virtue of the system, if they are not able to do it by virtue of the system, they can issue a manual order. This is also a manual order at page 339. So they can issue another manual order and give the advance tax credit of Polaris in the hands of the petitioner. So this consumption of advance tax is at their end, not at my end. We have not consumed it.
Yes.
Yes, my lord.
Only this is the area of conflict remains.
Yes, my lords. In this petition, the moment, my lords, advance tax credit of Polaris shows at serial number 10. In
Yes.
this chart, my lords, my grievance would be solved.
So the advance tax paid by Polaris needs to be deducted
Yes, my lords.
while
Yes, my lords. Yes, my lords.
Mr. Prasad.
But what, as I've shown to your lordships, page 2 with regard to 1920, what they have stated ITBA is, as seen from the CTC portal, mentioned challans, that is advanced tax challans. TDS has already migrated, no difficulty about that. Mentioned challans are already consumed. So they are consumed by the Polaris, by Polaris. And challan correction cannot be inverted for already consumed challans. But this note, they have suggested the following steps, where they have said, note, you
Mr.
pass
Prasad,
the activity-
what we feel
Yes.
is that you can have a word with your counterpart. You also join Ms. Kapoor, have a word with Mr. Prasad, and then you jointly you make a,
Yes,
then this can be sorted out. This is not a big issue here.
Yes,
Uh,
yes, my
You have a word with her and
Yes.
then
we will not. And
the next date we can.
well, on the next day, they can also talk to their client and then get instructions on this. Yes.
lords. My lords, the other two matters may be posted after 3 weeks, any date in July. My lords, I'll speak with my learned friend.
All right.
Very good.
This item number 9 and 10. Heard.
petition, not also will go with that.
Yes, yes, 9 and 10,
Fine.
both.
So great.
Yes.
Milord, this writ petition filed against part of the appellate authority and is a covered decision of the Honorable Court. In earlier instance, already narrated the facts. And your lordship directed to file the delay better affidavit in relation to delay and condonation this one. In this regard, I relay this circulars, Milord, CBIC, since tribunal is not constituted.
Tribunal is not constituted.
Yes, Milord, even this statement.
So that's fine. Tribunal is not constituted, that's fine. But is that the reason for approaching the court late?
Milord, there is a Honorable Supreme Court judgment also, it is there.
Honorable Supreme Court judgment goes against you.
Milord,
You have challenged an order dated 26/2/2021 of the appellate joint commissioner by filing a writ after 2 years. Why?
Milord, there is a consistent.
Yes.
Yes, sir, please, please. There is a consistent pressure of the respondent 3 because they have the credits issuing multiple reminders asking me to pay the penalties by a third show cause notice, Milord.
So because of that, you should have rushed to the court at the earliest. Instead, you have come after 2 years. So, have you said anything in your better affidavit? Have
Yes.
you filed?
Yes, Milord.
Let us see the better affidavit.
Page number 4, Milord.
Better affidavit. Page number 4.
Serial number 2.2.
Yes.
The petition in spite of available facts are supra. The petition humbly submits to the Honorable Court.
Where?
Subsequent to issue of show cause notice.
Where are you reading?
So page number 422, Madam Milord. Better affidavit.
It is not there.
I filed on 7th, Milord, 8th.
Yeah, it is before us. Paragraph
2.2, Milord.
2.2.
Last one.
Where is that? Yes.
The petition in spite of available facts are supra. The petition humbly submits to the Honorable Court subsequent to issue of the show cause notice 23/7/2022. That is, third show cause notice on transit credit. Multiple reminders dated 8/8/2022, 4/2/2023, and 17/3/2023. Issued that. And against this, I filed multiple representations, replies also, Milord, and paid to consider submissions. Considering the persistent continued pressure from the department and owing to non-constitution of the GST tribunals, there is no alternative remedies exist, Milord. And they're pressuring me to pay penalty, and they wanted to, because withhold my refund also, Milord. And against this, I already filed the petition with this Honorable Court.
So this explains 2 years of delay.
Milord, there is a.
I suppose in your law school there was a paper on the pleadings and drafting.
Milord, my please, Milord.
2 years of delay. How do you explain? What happened? Some fever or some stomach pain? Stomach pain, of course, cannot continue for 2 years. Something like that.
Milord,
Marriage in the family, some.
Because tribunal is not complete. Page number 60, it was there, and COVID limitation is
better. This is a worse affidavit, not a better affidavit. You have to explain the delay of 2 years. Why should we? But though there is no limitation in filing writ petition, but still, we want to know. You must know that why you have approached this court after 2 years.
Milord,
More so now when you say you are being bombarded by the authorities, pay this, pay this, pay this. Some imagination, is it not? Some imagination. I lost the papers, too many files in the chamber, or rainwater seeped inside the chamber, destroyed the files, something like that.
Milord, and they're passing assessment orders. And
No, we can understand the,
There was
but you must help us also to help you.
Milord, there is a Supreme Court judgment. That is the reason I mentioned it.
What is the Supreme Court judge?
Page number 60, Milord.
No, what does it say?
on account of the COVID limitations, my lord.
COVID.
COVID-19
Say
limitations.
that, but where is it? You have not said that.
I stayed, my lord.
Where have you said? Because of COVID, I could not go out, go to my chamber. I was confined in my bedroom only. Where is that?
My lord, there is a page number 5. And Honorable Court miscellaneous petition on account of cognitive extension of limitation on account of the COVID limitation.
This, we'll have it next Friday. And list this matter again on next Friday, huh? Next Friday is 16/6. Yes.
44 entities, they are filled it. The urgency, the playground of the school has been occupied by some encroachers, made constructions. The lordship stayed the matter, my lord.
Yes, there is a stay.
Yes. I request you to take up 14th or 15th because the schools are opening on 12th, my lord.
16th we'll have it.
Instead of Friday, lordship, Wednesday or Thursday, my lord.
Thursday. All right, Thursday. Please.
Much obliged.
We are in agreement with the view expressed by the tribunal on this issue. Thus, this issue is also answered in favor of the SSC. Therefore, on a thorough examination of all aspects of the matter, we answer the questions proposed by the revenue as substantial questions of law against the revenue and in favor of the SSC. In that view of the matter, we are of the unhesitant view that the substantial questions of law framed above are to be answered in favor of the revenue and against the SSE. The substantial questions of law are answered accordingly. Consequently, all the appeals fail and are accordingly dismissed. For all the aforesaid reasons, we are not inclined to interfere with the impugned summons, authorization and notice, which would now be constituted to be pertaining to investigation, verification of the claim of the petitioner to transitional credit in the state of Telangana. Writ petition is accordingly disposed of.
Sir,
Not subject to lots of kindly, Lord, on CRP, Lord, arising out of CS 14, Lord, it is allotted to this bench, Lord, lots of kindly next week, Lord,
Next Friday?
next Friday. Another writ petition also.
Yes. Yes, Mr. Fernandez, what is the position?
Yes. During the vacation, we made several efforts, Milord. With the bank, State Bank of India, the general manager got transferred. So there's a new lady that has come in. She has requested, even this morning, I have spoken to her twice. Apparently, what I understand from the conversation is there is something there, but she doesn't know what exactly it is. It doesn't know what the contents. I said, you give us that at least in writing. And it is also informed to us from the customs in Mumbai, Milord. May I pass on these letters? I've already shared this with.
Kindly give a copy to them.
I've given them.
Yes. What is there?
It is with the CIU Mumbai wing, my lord, intelligence unit. They say that unit.
You have a
will
copy?
My copy I have given, my lord, accident. I'm sorry.
Kindly read.
Yes. In this regard, it is learned, the second paragraph, my lord, because we have written to the Additional Commissioner of Customs, CIU General, New Customs House, Ballard Estate, Mumbai, 400, whatever. They respond, my lord, please refer to your letter dated 5/2023, received from this office of the Chief Commissioner of GST and Customs, Hyderabad Zone, on the above mentioned subject. In this regard, it is learned that the case is being dealt by CIU General Zone 1, New Customs House, Mumbai. Accordingly, a copy of the letter is being forwarded to provide requisite information to the concerned commissionerate under intimation to this office. However, we made phone calls as well, my lord. Right now, they don't have any information, but we have asked them to dig deeper, my lord. Because it's 1952, my lord, nobody has records of it. The bank seems to have something, my lord. We've written several letters to the bank as well, my lord, in this. If your lordship wants, I'll pass on those letters that we've written to the bank.
What will do?
So now, my lord, even in Customs House, Mumbai, they are expressing some difficulty in getting it, but they are trying, my lord. We've at least made some inroads as to knowing which department will have that information. And the bank says there is something, there's an administrator that is dealing with this. They're going to check the respondents. And if that information is there, they will provide that, my lord. In fact, she said by 2:30 today, she will send it. She has not sent it yet, my lord. Yesterday also, we requested them, my lord. I think lordship may grant another 2 weeks if that lady is able to provide this information. In fact, an order went from the court as well. When the officers went, the order of the court also was received from the bank. They've taken a legal opinion from their lawyer about this as well. So
We'll have it after some time. In July, we'll have it. Yes, please.
Because there is a double claim. They say that the 26 items which is in a sachet, in a suitcase, and they are claiming 5 trunks of property which is also deposited with this very same SBH bank. So once for all, let the matter be decided, or else what will happen? These 26 items, again there will be a conflict with other property. So your lordships may kindly direct the SBH at one stretch. What is the order which has made the 5 trunks to be deposited? I've got evidence to that effect. There is a property. I will file the record if this honorable court so pleases that the property is intact and it is under the custody of the Jagir administrator. There is an order pertaining to CS 7 only. So this is with regard to the head of the family, the then head of the Amir-e-Paiga, taking away the property from India to abroad without the permission. So there were 26 items only. What is happening is, on the basis of the 26 items, they are claiming some other property, that too on a document which is meant for some property deal. So it's a pure fraud which is being committed on the court. As per the law declared in Chengalvaraya case, a person who comes before the court with unclean hands, good, this is not natural consequence. So for once for all settling the matter, anyhow your lordships is granting up to July. kindly direct for the other property is also deposited, attend to CS7. I'm not asking anything other than that.
Is it necessary?
May I say this?
Page 35, no? I think in that context, we have to, as talk for the status of the jewelry. For the appellant,
Appellant, one Srimati Sneha Bogle is appearing. I am appearing for one of the defendants.
she is here. Otherwise, the appeal is against this order. That the petition was ordered reserving liberty to the petitioner to approach the appropriate authorities regarding the alleged jewelry property seized by the customs authority.
That is customs, but in another writ petition, there is a connected writ petition, my lord.
We are only concerned with this appeal.
Yes, my lord.
Appeal is the scope of this appeal is only in this connection. We wanted to know what is the status of the
Yes.
thing. Now you say it is under this commissioner, right?
Yes.
I think that's fair. That's the information we wanted.
No, my lord, but
With this information, we can. There's hardly anything left in this.
they have transferred it to that commissionerate, not CIU Mumbai, my lord. But orally, we have asked CIU Mumbai to give it to us in writing. They're saying right now they don't have any information, but they're going to dig deep because it's 1952. That's why I requested some
All
order.
right, fine. Is it not? Yes.
May I say one more thing, my lord?
But of course, she is not present today. So we'll put under the caption for dismissal on the next date.
May I say this, my lord? Council says he has an order showing evidencing that it's there in the bank, my lord.
Bank, it is there.
So it is for the appellant who has challenged this order to approach that authority.
Yes.
And meanwhile, giving us also liberty to put forth.
You have not filed appeal against this. Have you filed appeal against this?
I am respondent.
Then why should you pass an order in favor of the defendant in the appeal filed by somebody else?
But the property belonging to us, somebody else is claiming. That is the whole problem.
My lord, Sneha had called me, the counsel for the appellant called me in the morning asking if I'm going to take time. So I,
okay, fine.
I said, maybe she's not here for that reason.
No, for that reason. But she should have been present.
Certainly.
None has Main 73 पे क्या है? Set aside abatement. Can't do. 73, yes. Yeah. Set aside abatement, what is to be done? Can't do. 73, yes. Yeah. Set aside abatement, what is to be done? None appears for the petition. Yes. Yeah. Set aside abatement, what is to be done? None appears for the petition. Yes. Same. Set aside abatement, what is to be done? Yes. None appears for the. Can't hear you.
Senior CH Dhananjay is appearing, my lord,
Huh.
in this matter. He requested 1 week time.
Last time, Mr. Mujibullah Sharif, learned counsel for the petition, has undergone surgery. List after summer vacation, so and so.
Yes, my lord, in this matter, the senior counsel Dhananjay is appearing, my lord.
Huh.
He requested 1 week time, my lord.
Why? Yes.
He is in
None appears for the. Can't hear
Bangalore,
you.
madam. He is out of station.
Senior
CH Dhananjay is appearing, my lord,
Huh.
in this matter. He requested 1 week time.
Last time, Mr. Mujibullah Sharif, learned counsel for the petition, has undergone surgery. List after summer vacation, so and so.
Yes, my lord, in this matter, the senior counsel Dhananjay is appearing, my lord.
Huh.
He requested 1 week time.
7. Why? Yes.
He is in
Yet to be submitted.
Bangalore, madam. He is out of station.
Senior
CH Dhananjay
Await
is appearing,
service
my
of report
in this matter. He
by the
requested 1 week time.
newly appointed. Last time, Mr. Mujibullah Sharif, learned counsel for the petition, has undergone surgery. List after summer vacation, so and so.
Yes, my lord, in this matter, the senior counsel Dhananjay is appearing, my lord.
Huh.
He requested 1 week time.
7. Why? Yes.
He is in
Yet to be submitted.
Bangalore, madam. He is out of station.
Senior
CH Dhananjay
Await
is appearing,
service
my
of report
lord, in this matter. He
by the
requested 1 week time.
newly appointed. Last time, Mr. Mujibullah Sharif, learned counsel for the
Lord.
petition, has undergone surgery. List after summer vacation,
Yes.
so and so.
Lord, I am permitted
In this
to
matter,
represent
the senior
A.
counsel
Rajita
Dhananjay
madam,
is
Lord.
appearing,
She is applicant
This
going to
is
file, she is out of station.
7.
Why?
Now, my
He is
instructions
in
are that, Lord, in this matter, the review application is pending in the Supreme Court. That is first aspect.
Await
The
service of
second aspect
report
is, my lord, in view of the
by the
appointment of the new commissioners by these
newly
honorable
appointed.
courts,
Last time,
now this degree holder perpetuating the further fraud by alienating the property, my lord, of CS7 in spite of
Yes.
the prohibiting order. I am permitted to represent
on
4/1 A. Rajita madam,
2000
she is applicant going to
this
file,
is
she is out. This honorable court has passed an order. Lordship may kindly permit me to read the relevant para. Well,
Where is that order?
Yes, in writ petition number 16639 of 2020.
So we don't have. No.
I have got it. No.
Not it was carried to Supreme Court. Supreme Court has stayed that order.
There is a stay what is Supreme
Yes,
Court.
by Supreme Court, there is stay by Supreme Court on this order.
My lord, I will read the relevant portion for lord's substitution.
No. We don't have a copy. You don't have extra copies of this order. What is this, sir? If when you place some, when you rely on some document before the court, at least copy should be there for the judges. If you give it to us,
Yes,
from where
yes,
you will read?
Yes. There are 4. I'm sorry, my lord, I have to cancel all the record.
Yes.
The para 4, my lord, lordship is pleased to observe
Yes.
that this property, CS, this property cannot be sold. There is no question of registration. Now, in spite of that order, now perceiving, my lord, the outcome of the result of these new appointed commissioners, now he is surreptitiously perpetuating the fraud by selling the property through this another Dharani portal, lordship may kindly say. Because which he could not
No,
have
from
done.
where you are saying all these things?
Lord, these are Dharani portal.
No.
Let us
The
read.
Dharani portal, all this, from where you are saying? We are in a civil matter, is it not?
Yes.
We can't, any document we can't.
I appreciate you, Lord. My humble submission is I am just bringing to the notice of the Lordship's notice how he is perpetuating the fraud in spite of the court's order appointing new commissioner for the purpose of passing a new final degree. Now, he has no fear of any sort, Lordship may kindly appreciate. Honest construction.
In the air.
Let him file the document.
Everything, whatever you say, you must file some document, some affidavit. You must file.
Next date of him. I'll try. Milord, at least he must respect the court. He is a crude criminal. He is going on perpetuating.
Don't say all these things. He is not there before us. Without filing any application,
We'll
you
file.
can't say somebody as a criminal or something like that. That's not done. What is your name?
I'm Mr. Narayan Lakshman Rao.
Mr. Narayana Lakshman, appearing on behalf of?
K. Rajita.
Who she appears for whom?
The impleading petitioners, my lord.
You are not yet impleaded.
No, my lord. Not yet impleaded, my lord.
Respondent numbers 1 to 8 in the review petition.
May I request, my lord, I am only seeking a time because representing that she is out of station.
All right. List this matter
Take the steps.
after 4 weeks. On 7/7/2023. See, you can't simply walk into the court and then start making all kinds of submissions. This is not permissible, all right?
No, I'm sorry.
We are telling you in a proper manner, but next time we'll be very harsh on anybody who comes to the court and simply walks into the court and makes this type of submissions, all right?
Look,
Please keep that in mind.
my lord,
Please.
I apologize, madam.
Yes.
Lord.
My lord, these two matters, my lord, 61 and 62.
Yes.
This is coming up for the final degree, my lord. Since the commissioner has to file a report, your lordship may attend this matter and let him file the report. Basing on that, your lordship can pass a final order. And we don't know whether this properties is available for the partition or not. That's also a question.
All of you are residents of Canada. What will you do in property in Hyderabad? Huh? Huh?
And whatever it is not available also.
All right. Await submission of report. Sixty-two, 63.
So I appear for the petitioner, my lord.
Yes.
Your lordships were pleased to defer this matter, my lord, since the report, my lord, of the receivers was not filed on the earlier occasion. The position seems to be the same.
The same order as the earlier one, huh?
Yes.
14-7. Yesterday they came and left me. No, they prepared me. Yes.
Coming up for counter of respondents, my lords, not already granted stay, my lords, of the GOMS.
Let us see, let us see. Only in national 20, 29, 30. Stay. Yes, Mr.
That's 2 more weeks, my lord, filing.
You're required to file counter affidavit.
Yes.
When will you file?
2 more weeks, my lord.
2 more weeks. Mr. Parsha Anand.
All these matters, my lord, are very.
These are all objection by the office.
Yes, my lord.
And it is pending since 2016 with office objection. There is nothing, Mr.
Lord, appointed, my lord, the receiver.
So we can close it?
Lord, the receiver files.
No, no,
my lord,
these are all pending since 2016,
Yes,
18.
yes, office objections, my lord, they are taken. But if report is filed, my lord, it will be closed once for all. New receiver, my lord, 23/1/2000.
Represented,
23, my lord, largest appointed. On that day, these matters were listed. Largest appointed, my lord, the new receiver.
My lordship, I'm respondent number 1 in this application. Already the title of the petitioner has been set aside by the division bench. First, he claimed 7/1 application as a final degree, and that final degree got set aside by the division bench.
He wants to, my lord, argue, my lord, we are ready. Next week, your lordship may kind of take up, my lord, this item 66. Insofar as others are concerned, my lord, they have to, my lord, await report.
It is pending for final degree, my lordship.
Lord, this application item 66, my lord, is, my lord, the sole sharer, my lord, dependent 58. She sold her decretal rights, my lord, in the year 64 itself. My lord, she is claiming, my lord, right over the property after, my lord, selling the property. That's the reason why, my lord, this application is filed.
This
now,
yes.
Now, my lord, she is no more. My lord, this petitioner, my lord, is my lord, filing
My lordship,
application.
this is for 7 number 1.
Applicant is also no more. Then there's nothing survives.
Not applicant, my lord, respondent, defendant 58.
I am the respondent.
He is coming, my lord, as LR of defendant 58 as sole LR. My lord, there are other 5 or 6 persons are there, my lord, claiming as LRs. My lord, there is a dispute with regard to, my lord, declaration of LR.
See, your application, this is the prayer bill.
Yes, my lord.
Just one minute. To direct respondents, government authorities not to entertain, consider any complaint claim raised by respondent numbers 1 and 2 with regard to the land covered by suit in civil suit number 14 of 1958 against the final decree holder without providing opportunity, and also direct respondents not to harass final decree holders at the instance of respondent 1 and 2 with regard to possession, enjoyment, development activities of the land covered by. So how come in a civil suit you can file this kind of application?
It is, my lord, against the sole sharers, my lord. They have sold their decretal rights, now claiming, my lord, the rights over the property without paying.
The suit is yet to be finally disposed
That's
of.
the reason why.
Then how can you file this type of application?
If the report is filed, my lord, this can be.
Your rights will be protected. No, you are as a Murali Krishna, Goldstone Exports Limited. How come this?
My lordship, I just wanted to pass this.
1 minute,
Sorry.
please, sorry. We are of the view that this application is not maintained.
Next week, my lord,
Next week, once it is before us.
Senior council is there.
Senior council will, even if senior council come, 10 senior council come, it will not change the outcome.
Yes, at the presence of senior council, my lord.
Why senior council? This is okay.
The defendant, my lord, 58 and my lord, they are claiming as a loss of defendant 52.
Page 7.
Final degree has been set aside, my lordship.
Can we issue any direct, even under 226 proceedings, can we issue any direction to the state government not to entertain any objection against this person? Can we say, can we?
Not against to say it is a civil.
That is your prayer. That is your prayer.
Government is also party. We are seeking direction against the unofficial response. Next week.
Mr. Krishna.
Next week. See, at the presence of senior council, it can.
My lordship, their final degree has been set aside.
All right.
Their mutation has been set aside.
Is this matter 66 under the caption for dismissal on
That 67, 68, this can be your largest appointed
Greater Golconda Estates Private Limited, Sai Pawan Estates Private Limited against Mrs. K. Lalita, Raja Rao, Elisha, Saritha.
These are these applications.
They are neither parties in this partition suit.
Under Order 21 Rule 97 and 99.
So the prayer is to remove the obstructions by the respondents or persons claiming through them in handing over possession of the land to the final decree holder. Where is the final decree? In pursuance to the order of this court, and delivered a vacant peaceful possession of the land by demolishing unauthorized structures if any of the petitioners, by providing necessary assistance and police aid to receiver cum commissioner and GHMC authorities. You have converted this into a writ petition. This is not a civil suit.
No, Order 21 Rule 97 provides. That's the reason why this. The largest mechanical adjourn for white report.
Under the same caption, dismissal on next Friday.
But instead of for orders,
we are very clear that we should not entertain this type of petition. As it is, we are not short of cases.
Same,
under same caption, 68 also. None appears this case. None appears for the petitioner on call. Petitioners on call. Dismiss for non-prosecution.
Sir, 70 and 71, my lord, both are, my lord, final decree applications, my lord.
Yes.
In respect of, my lord, survey number 163, the lordships appointed new receiver, my lord, let the report be filed.
Praised, yes. Petitioner herein praised that this honorable court may be pleased to direct Tehsildar, Shamshabad Mandal, Rangareddy district to forthwith update the revenue records by implementing the mutation proceedings contained in file number so and so, and consequently record the applicants as owners and possessors of all that land in survey number so and so as contained in the mutation proceedings. I suppose we are in a partition suit. Then what is all this?
Madam, this your lordships may kindly.
We are going here, sometimes we are going here, sometimes going this side.
This your lordships may kindly permit me to withdraw with
You
liberty,
withdraw this, sir. That is
liberty to file.
what liberty?
With liberty to file, my lord, if it is.
All these properties are claimed under the guise of compromised degrees, my lordship. There is no final degree passed.
They told that the creator rights, my lord.
Let us now pass the order.
My lordship.
Outside you go and whatever you do amongst yourselves.
Seventy-one.
Let us see. Sahib Sahib. Trinity Infra Ventures. Okay. 25. Pass a final decree in favor of Trinity in partnership.
After filing of report.
Directed. See, pass a final decree in favor of petitioners 3, 4 and 5. 3, 4 and 5 are Trinity Infra Ventures Limited, PS Parthasarathi and Shuvishal Power Gen Private Limited. How you have come in? Who has sold land to you?
The defendant 206 and 157.
As per the surveyed plan for an extent of 16 acres. Who gave you 16 acres? The partition took place as per
Decretal rights relating to that property. Decretal rights were assigned.
Under the assignment.
Direct receiver come commissioner to put the petitioners in possession.
Decretal rights, Lord. After filing of report, largest mechanism.
Hmm. We can't do all these things here now. On which final decree on you became owner of that property? Whereafter, where is the sale deed say transferring the land to Trinity, Parthasarati, Suvishal? Where are those documents?
I will file Millard all those documents in respect of this land, either Nagar village, Millard item 38.
Who sold you? Sahib
Millard, it was
Zadi?
allotted to Millard two defendants, defendant 157 and 206.
Ah.
As per the report, Millard of the receiver.
They sold you.
They have executed a decretal rights, Millard, assignment of decretal rights, Millard, in favor of these petitioners.
Can it be done?
Millard, the report was filed, Millard, in the 13/7/84 itself. That report has become final. Millard, basing on that, several final decrees were passed. Millard, these defendants 157 and 206, Millard, have executed, Millard, the registered assignment deed.
So you do whatever you feel like, but don't come to us. If you come to us, we'll have to look it from a legal perspective, is it not? All this hanky-panky business you do outside, not through the court process.
This can be, Millard, awaited, Millard, till the filing of report. New receiver.
All right, list after 1 month, then we'll dismiss it.
Yes, ma'am.
Uh-huh. That's what we are asking. How these people have come in over the land?
206.
Hmm. Now they have become also like revenue officers.
Yes, my lord.
They want a direction to them to have, put them in position. So they have become so powerful.
It is, Millard, the receiver, Millard, is in possession of the property, Millard. That's the reason why, Millard, we are.
There's no, he has been removed. Now we have a new receiver.
New receiver came up, Millard.
Let the receiver be in position.
New receiver came,
A
Millard.
new receiver be in position.
New receiver, Millard, will.
No, we'll not say anything. List this matter again on 14/7/2023.
Also, Millard, are similar applications which are filed for the final decree, Millard. Those also can be awaited for the report of the commission. These are the property holders and the
Today's law may
defendants in
become,
the civil suit.
and today's
Original-
crime
You have
may
not
become
yet
tomorrow's
given
law.
up your shares to others.
No, others. They are the defendants.
Nobody has given the share, my lordship. There is a Nizam statement which says he never purchased the properties and that order was subsequently received as a wrong back in 1967.
Okay. You want a decree in terms of compromise.
Compromise between the family members only, Millard. They are also entitled for a share in the, which is in the possession of the mother. Her mother expired, and these properties which are in the name of this mother, which are allotted to her, they want them to be shared among themselves. That is a compromise only with regard to that proportion.
Await submission of report. This 72 to 80.
72 to 80 minutes.
Submission of report by the new by the receiver cum commissioner. List on 21/7/2023.
But this writ petition, Millard, I am permitted to withdraw, Millard. It has become infructuous.
You want to withdraw?
Yes, Millard. It has become infructuous.
Yes, Mr. Krishnaya, learned counsel for the petitioners, submits that Mr. Krishnaya, learned counsel for the petitioners, and Mr. Partha Anand Nageshwar Rao, learned special GP, revenue for the respondents. Learned counsel for the petitioner submits that the writ petition has become infructuous, dismissed as infructuous.
Millard, In respect of this, my lord, the final decree application is pending. My lord. Earlier, there was a final decree that was set aside by the Supreme Court. My lord. Now, application is pending. Application for Nala, my lord, is my lord, rejected. That's the against that, my lord, the writ petition is filed. So, lordships may kindly, my lord, adjourn this, my lord, for 4 weeks. In the meantime, my lord, the final decree is passed. We will pursue. Otherwise, my lord, it will be.
I filed my implead in this, my lordship.
You have filed implead petition. Yes. You have any objection to his implead?
Blood, I have to file counter, my lord. Because they have no blood.
My lordship, subsequent filing of this case.
Conversion of the land. Final decree, then thereafter land with request for conversion will be considered. Name payment. Mr. Krishnaya, doesn't your prayer here? It's like putting the cart before the horse. You want direction to the respondents to accept this conversion charges,
Yes,
right?
Yes, ma'am.
Decree is yet to be, final decree is yet to be passed. Then after final decree, prayer will be made for conversion of the land.
In 2011, there was a final decree.
That's gone.
That's the reason why, my lord.
Then there's nothing survives in dispute. That's what we are saying.
If it is, my lord, the new receiver comes, final decree is, my lord.
Then what will you do?
Lord, your lordship may kindly adjourn it, my lord. After 4.
This is premature. That's what we are saying. You're putting the cart before the horse. It is premature.
That's the reason why, my lord.
Once the decree will be there.
Lord, earlier.
If you succeed, then your application will have to be there for conversion.
They'll have to make an application.
That's the reason why. Your lordship may kindly.
We will say, we'll give you say.
I will seek instructions, my lord, whether to withdraw, my lord.
We will say that post final decree, petitioner would be at liberty to revive his prayer. That's as is it?
But my lordship, we are in possession of the land.
Next week, your lordship may kindly have it, my lord. I will get instructions, my lord, with regard to.
Premature, absolutely premature.
Lord, prior to filing of this writ petition, my lord, there is a final decree. Lord, the Honorable Supreme Court said, my lord, this Honorable Court said it is not a final decree, it is a recording of compromise only. Lord, that was confirmed by the Supreme Court. Basing on that, my lord, final decree application is filed. It is pending before this Honorable.
They don't have a title, my lordship, as per the division bench order, paragraph number 55. This clearly said, if the
They
title.
don't have title, my lord, they won't have any title. They are claiming dependence in the suit.
Therefore, what we are saying, in the absence of a final decree, where is the question of directing the
I set
respondent?
aside their mutation, my lordship.
Application is pending before this Honorable Court, my lord. If it is passed.
We'll say this is premature as on date. It is premature. Parties are at liberty to revive their prayer once decree is passed. That's what we'll give you that liberty.
Again,
Heard Mr. Krishnaya, learned counsel for the petitioner, and
Lord,
Yes.
in this case, Lord, the applicant's advocate, that's Mr. Trilok Bahadur Sehgal, passed away. And what happened in this case, my lord, application 797 of 2013 was filed, my lord, to implead by Syed Hasimuddin Ali Hussaini. My lord, subsequently, my lord, he died on 1/5/2016. And his LRs, my lord, have filed applications, my lord, to come on record on 22/2/23. But what happened, my lord, on 23rd February, the matter has been listed before your lordships. And since there was no representation, since the council was no more, your lordships were pleased to dismiss the same, Lord, observing the contents of the application by your lordship's order dated 24/3, I'm sorry, my lord. Order is at page 65, my lord. 23rd February 2023.
Yes.
Since there was no representation as well as by the time the applicant died, my lord, the counsel for the applicant has also died. And just prior to that date, my lord, we have filed applications, my lord, LR application to come on data because they are in the USR stage, my lord, they were not been put up. And the matter has come up before your lordships.
No, the prayer was.
Yes, my lord,
We have recorded in para 3.
Yes, my lord.
That in para 10 of the supporting affidavit.
Yes.
Applicant has made a statement that as the Atiyat Court, Commissioner of Survey and Settlements and Land Recovery, has already determined his share, including court decree, he is not interested in getting his share determined in this proceeding, except to get implemented. Thus, contention of the applicant appears to be purely academic. This is a.
That is true, my lord.
Then?
Actually, in fact, my lord, those proceedings, my lord, determined the rights of the petitioner in title. But maybe I cannot say, my lord, the council who has filed this application at that juncture, my lord. Then maybe.
But you cannot now disown this statement.
Of course, my lord, that is.
This is a statement made on oath, on affidavit.
Yes.
You can't disown this statement.
That is true, my lord.
Sir, namaste, sir.
Because.
Who are you? आप कौन है?
I am the Hindustan Aeronautics Employees Cooperative Housing Society, sir. We purchased land during the year 81-82, sir, registered sale deeds. And same land, many people are coming and getting orders from the court and harassing us, sir. That's in that reason we filed a case in the High Court. High Court also passed an injunction order against them, and Supreme Court also his case is pending. All the parties are respondents in that case. So once again, application 946 and 946 of 2008 is filed by a final degree. That is also is pending. Again, number of another case filed and coming for a final degree, sir. So
therefore, we have dismissed the earlier matter.
That's why I am requesting, sir, give me permission to appoint advocate, sir.
Appoint?
I want to engage advocate, sir. Then only after here.
No, this matter has already been dismissed.
This has nothing to do with that gentleman's case, Miller.
See, we are not inclined to revive this. Whatever order we have passed, we have passed. We are not inclined.
If at all, Mirror, let them work out their remedies. We have got any. In this case, he has no.
That same parties are not others.
Which one?
Applications 1 to 4 of 2023.
Sir.
Yes. These applications have been filed for a restoration of application number 797 of 2013 in CS number 14 of 1958. Application number 797 of 2013 was dismissed on 23/2/2023 in the following terms. Entire order put. First off, we see no good reason to restore the said application. Be that as it may, interest of the applicants, be that as it may, claim of the applicants would be bound by the final decree that may be passed in CS number 14 of 1958 on the basis of the report that is to be submitted by the receiver cum commissioner. Subject to the above, the applications are dismissed.
Public.
Yeah. Yes.
The report is received by the receiver.
Okay. This 84, 85,
Yes.
list 72 to 78 along with that.